Hello, my name is Dr Ciarán O'Kelly and I'm the Deputy Head of the School of Law here at Queen's University Belfast. We're speaking today with Dr Dr Bosse, who's a lecturer here at the school, specialising in the history and politics of intellectual property law, especially around plant varieties. Jocelyn's primary research interests focus on the complex relationships between intellectual property rights and food, biodiversity and Indigenous rights. She's just been awarded a hugely prestigious UK Research and Innovation Future Leaders Fellowship. We're going to be talking about that today. The Future Leaders Fellowship involves a really significant piece of funding across up to 7 years that is designed to support novel and ambitious research and innovation. And Jocelyn's project, co-led with Susanna Chapman at University College Cork, is entitled A Century of Propertising Plants, examining the role of intellectual property law in protecting biodiversity and food security. And we'll be talking about that in a moment. You're very welcome, Jocelyn.
Thanks for having me.
I suppose, Jocelyn, it would be good just to start with a little bit on really what is intellectual property law. It's always struck me as being quite a strange part of our legal ecosystem around our economy. That is a market-supporting, market-restricting method and instrument within law. So what is intellectual property law?
It's a very good question, Ciarán. Intellectual property law, the way I think of it, is as this umbrella term that encapsulates lots of different things, different legal mechanisms that are trying to achieve different goals, and that we've given the collective term intellectual property. It brings together everything from copyright law, which is dealing with the rights that we give to authors to reward them for the creative efforts that they have put in, and hopefully to help allow them to make a living, right through to patents, which protect inventions, thinking of things like pharmaceuticals and the patents that allow pharmaceutical companies to have that temporary monopoly that allows them to control access to drugs and important medications for up to 20 years. And it also includes trademarks. So this is something we would see every day when you go to the supermarket and think about which brand of whatever product you like to buy. The trademark is how you might identify it. These are very different rights, and each of them is meant to perform a different function, and yet we couple them all together and think about them as these exclusive rights that allow some to control aspects of the market, from medicines right through to the brands that we see every day.
So allowing us to control, this is about law protecting something. It's protecting ownership, it's protecting the capacity to make a profit from innovation. Would that be right?
That's the idea. So the idea is that profit should be an incentive for people to keep on innovating, to keep on being creative, or develop well-known brands that have a strong reputation. That's the idea behind it. Of course, we can talk about whether that is the reality that is coming through.
Yeah, that's where I was going to. What's the reality?
Well, the reality is quite complicated, and it's especially complicated in an area of intellectual property that I focus on that actually gets very little love when it comes to these conversations, which is the intellectual property rights for plants. Now, this is an area that overlaps in some ways with patent law. So some of the inventions that get protected by patents might be plant varieties, but it's also an area where we have a separate form of intellectual property that has different names depending on your jurisdiction. Here we might call them plant breeders' rights or plant variety rights. And those are a sui generis form of IP that allows breeders to have their innovations protected for, again, a set amount of time. Although in this case, it might be anywhere from 20 to 30 years in the EU. And that allows them to control access to that variety, who gets to grow it, and making sure that they're making money when we buy apples or when wheat is sold to make our bread. Those are the kinds of products that we're talking about.
Isn't that just kind of controlling the natural world or controlling our access to the natural world?
Well, this is one of the big anxieties that people have about plant intellectual property, and this has motivated a lot of the literature and the both policy work and academic work that has been done on this area of law in the past. People are very concerned, and have been for a very long time, about the mere idea of intellectual property rights over nature, over natural things. What's interesting, though, is that it's also about stabilizing what it is that we're talking about here, that we think of the natural world as something that is ever-changing. It should be allowed to continue as it always has, which might be through creating new diversity, new varieties popping up through evolution, but also keeping the plants that we know and that we love, that we want to see in our gardens every year, and that we want to be able to eat and find at the supermarket. So there's that tension going on there between these ideas that we have of nature as something that is stable and something that is always developing, that then comes through in my research on biodiversity.
Well, that's very interesting. I suppose for me, we could imagine a sense where we think of nature as something that's pristine and independent of human intervention, I suppose. Would you see intellectual property law really as tracking change there, tracking a kind of a long-standing manipulation of the world, or maybe an acceleration in how we manipulate what would hitherto be a kind of a pristine natural world?
I think that's right. So one of the things when plant intellectual property rights first came on the scene, and we're talking here about the Plant Patent Act of 1930 in the US, this was exactly what they were talking about, was recognizing that humans in collaboration with nature are able to bring about changes in plants, from small mutations that might randomly occur on your peach tree in your backyard, and being able to stabilize that and bring it to the market to make sure that year on year people can continue to eat those lovely new peaches that you found. And so recognizing the role of humans there and rewarding them for that and encouraging them to bring those things to market was what they had in mind initially. But this idea of that stability of nature as well has a very difficult role to play, because on the one hand, when we listen to government officials and some economists talk about plant IP rights, one of the benefits that they see to having this system is that they want to encourage more of that diversity being introduced, for people to identify where plants have that variation and to keep that going for year on year, bring it into breeding programs and introduce that diversity to more varieties. And so in that way, they would say that intellectual property can become almost a measure of diversity, that every time someone is registering a new plant variety right, what they're doing is saying to the government and to the world, hello, more diversity has been added to our food system. And that, we might say, is a good thing. But at the same time, we have these narratives going on about loss. This is a very important narrative that has been prevalent in the literature from anthropology through history to look at what has been happening over the 20th century and 21st century with things like the industrialization of agriculture and how that becomes intertwined with intellectual property rights. What I'm saying here is that many people have expressed concern that with the advent of plant IP, these rights have become a mechanism for monopolization of agriculture. It's become a way to encourage monocultures and reduction of diversity. And so there are those who would say that actually the 20th century, with the introduction of plant IP as one of the features of it, led to catastrophic results for varietal diversity. And so now we're in a situation where the number of different varieties that are available to us on the market, the diversity of the food that comes onto our table, and logically by extension, people say the nutritional value of it and quality of it has massively declined. It's a big claim to make, one that runs completely counter to some of the other narratives we hear about plant IP. And so this is one of the questions that I really want to address with my fellowship is that true? Have we actually seen that massive decline? And I would question this because we have previous studies from the United States that show us that actually the picture is a lot more complicated. And this brings us back to your question about, do we think of nature as something that we like to be stable or something that can diversify and change? Because on the one hand, there are varieties that were available 100 years ago that we can no longer find. Maybe there's a variety of apple that your grandmother would have eaten that you couldn't possibly find these days. But we have still had all that innovation going on in the background. Whether it's human-led or not can be a different question. But we are still seeing new varieties come on the market every year. And we need to take those into account as well in that balancing and asking that question of how much that diversity has changed.
I mean, one of the words that you use a lot is stabilization. Seems like a kind of a term of art within this part of IP law. I mean, stabilization can be quite sterile and can denote something that's much dead, really. We expect nature to be messy and diverse. Would you see IP law across the 20th century as being part of that, a stabilization in quite a negative way, or you think it's mixed?
Well, stabilization, as you say, can have multiple meanings. Now, as you rightly picked up on, it is a bit of a term of art in plant variety rights because it's one of the criteria you need to fulfill to get a new variety registered. So you need to show that your variety is new, that you've actually got something that hasn't already existed, that you have innovated something there, and you need to show that it's distinct from all the other things that are already on the market and that it's uniform and stable. The reason why that's important is because if I'm selling you seeds to say, hey, Kieran, let's say you're a wheat grower, I'm going to sell you some seeds of this variety. It's great. It'll have better yield and it's got all these other interesting traits to it. Here you go. And you plant it and you get something else entirely. And I'll say, well, it's not stable. What can you do? Plants have variation. You'll just have to deal with that result. If you're a farmer, that's a really big problem, actually. And so part of what the law is trying to do there is reflect that need for stability and uniformity from that point of view of making sure that we have consistency in the production of our food. And so in that way, it can be construed as a very positive thing. But as you're also identifying there, this uniformity and stability can also be a negative. And those who see it as a negative are those who are trying to conserve these heirloom varieties, people who want to continue growing the same apples that we had 100 years ago to make sure they're still available. And maybe those older varieties don't quite meet those legal criteria that we're trying to impose on new varieties. This has been a point of massive debate for decades now. About 15 years ago, it meant the EU had to create this new category of conservation varieties in its seed regulations to make sure that people could continue selling those heirloom varieties. But at the same time, there is still that tension there with wanting to make sure that we have consistency and that people who are selling seeds or other propagating material for plants, when they're claiming what the variety is, you know what you're buying from them.
One of the things that's really interesting about that is a lot of the things that might denote, I suppose, a patentable plant variety are not legal criteria or legal categories. They're scientific. And reading your work and listening to talking about it, it really strikes me that there's a deeper scholarly innovation here. So in legal scholarship over time, we've had a lot of law and sub-disciplines. So we've law and economics, for instance, where lawyers are really drawing upon a reading of economic theory in order to explain, for instance, incentives in criminal law. Or we might have law and society scholarship, where we're deploying sociology to understand people's consciousness of law, etc. You have to go beyond that, don't you? You're really looking at aspects of science and technology in order to understand what the law can mean when it talks about questions like stability or innovation in this field. As you say, nature is full of change, so patentable change must require scientific knowledge as well. How do you navigate that? You can't be a complete expert in everything. Do you patently have a deep reading there of genomics, for instance?
Yes, well, I wouldn't pretend to be fully expert in plant science. I mean, I do have a plant science degree, but to the extent an undergrad degree can give you expertise, that's about as far as I go. But you're exactly right that thinking about, these law and categories and what they can contribute, certainly the law and science dimension is huge in my work. Now, I should say, of course, in terms of my own methodologies with my research, I rely very heavily on the methodologies from the humanities and social sciences. There's a lot of archival research there. I learn a huge amount from the historical literature. But at the same time, what we're seeing, and I'm certainly not the first person to do that, is that need for engagement with STEM and thinking about how the law regulates STEM, how the law learns from STEM, and what that interaction can tell us as researchers. So certainly there is already a body of research there that I'm drawing on, particularly things like law, science, and technology studies. So there we've got sociologists who have a lot of experience of working with scientists, studying what scientists do and the interactions with science as a social institution. And that's something that I'm very much bringing into my work here, to think very carefully about what it is that science can contribute and the relationship between law and science. And the reason why I think I wouldn't necessarily pitch this, though, as law and science in that terminology, though, is that sometimes you'll see when people talk about the law and science a particular attitude to what they think science is, which is something that they see as being quite stable, that it's got these particular norms and then it comes up with these certain outcomes. And I talk about science as being a social institution because actually things can sometimes be quite contested. Now, I'm not taking this in the direction that some might take it at the moment, where I'm trying to question the safety of vaccines or anything like that, but rather to understand properly how scientific knowledge is made and what the law's role there is. So to give a concrete example of what I mean, if we go back to some of the work that I did on cannabis regulation, and this is a paper I published in 2020, we have this ongoing narrative that the law is always lagging behind science. And so we need to learn from what the scientists and what technology is doing and regulate accordingly. And in that narrative, sometimes what gets missed is that actually the law can sometimes actually affect science quite directly and push it forward in interesting ways. So when I was doing the work on cannabis, what I found was that I'd been looking through a lot of patents in the US where people are patenting new cultivars of marijuana. And that, of course, is its own interesting phenomenon from a different angle. But what particularly piqued my interest was that all these patent applicants couldn't agree on how many species of cannabis there were. And you think that's a very basic question to ask of a breeder or a scientist is, well, what species is this plant? And so I started to look into why that was and found that actually when the war on drugs started in the United States, we have this criminal regulation of access to marijuana. And what that actually ended up triggering was taxonomists, plant scientists going out and looking at cannabis for the first time and saying, well, if the US government has told us that it's illegal to have cannabis sativa, what if you have cannabis indica? It's a different species. Does that mean you have no criminal charges against you? And what that meant was that there was this sudden flurry of activity from taxonomists looking at cannabis taxonomy for the first time in many years and realizing that maybe the picture was a lot more complicated. They never would have done that if it wasn't for those criminal regulations. Not saying the war on drugs was a good thing, but it does mean that we can look at these examples and say that maybe the relationship between law and science is different from the way common narratives might tell us it is.
It's a really good example of how law relies upon different disciplines, different kinds of expertise in order to know the world, and how it builds processes to bring something from kind of outside the institution of law into the institution of law, so judgments can be made about them and people can enter into dialogues about them. In that case, law had an imagined view of the world that then gets really disrupted.
Exactly. And it, allows us to ask very interesting questions about then what does the law do? Because it means that we don't just have to sit back and wait for scientists to tell us what the correct way to regulate things is. It means we can actually start to think about, well, what kind of world are we trying to create? What kind of science are we trying to push forward and regulate accordingly?
Oh, okay. So law in its readings of the world is actually regulating the expertise that it's drawing on at the same time.
It can be as well, yeah.
So really, kind of like nature itself, law is never really pure.
No, it isn't. And this is what I was coming back to, is that plant IP itself is also itself a bit of a law-science hybrid. And I think when I said earlier at the beginning that plant IP in many ways is a bit of a neglected area of intellectual property, people don't think about it so much or research it as much as the other areas. Part of the reason why that is because plant IP as an area of law doesn't always operate in the same spaces that we'd expect law to operate. So we don't get many court cases on plant IP. We don't have a huge amount of litigation being started in this area. And so people tend to forget that something is an active area of law if they're not seeing it in the courts or in the legislature. What we're instead seeing is a lot of complex systems that have been set up institutionally where lawyers are working with breeders and with a scientist who are doing a lot of the work to examine these plant variety rights. As you talked about earlier, we've got these technical requirements that are needed to get plant variety rights that are less about legal determinations like novelty and more concerned with scientific questions about whether or not a plant is truly distinct.
Okay, that's really interesting. So can you tell me a little bit, in a way, can you tell me what is plant IP specifically, but maybe rolling into that a little bit about the institutions that have been set up to create plant IP?
So plant IP is a term that I use as a bit of a catch-all because around the world, different forms of plant IP have emerged from plant patents that they have in the United States that allow you to get a special type of patent just for plant varieties. It comes with different rights compared to the patents that we have here in Europe, or indeed the utility patents that you can get for more mechanical or chemical inventions in the US. So there's that specific form of intellectual property, but then also that sui generis right that I mentioned earlier called plant variety rights, which is a system that really emerged in the 1960s to specifically protect plant varieties. And that law was very much influenced by breeders, designed by them to have strong exceptions to allow them to freely do their breeding, other exceptions to make sure that food security could be protected by allowing farmers to some degree, retain seed every year. So there's that area. But then more recently, we're starting to see what we might call normal patents or utility patents also emerging as an important aspect of the regulation with the advent of gene technologies. So since the 80s, once genetics and biotechnology really started to move forward, people became more interested in getting patents on the traits for plants. So then we're seeing gene patents coming through, as well as other aspects of the breeding process. And this has become very crucial now with the advent of things like CRISPR or gene editing technologies.
Okay, so a trait is not necessarily the very old-fashioned examination of the physical traits of a plant. There's something else going on there, is there?
Exactly. So these might be the aspects of the plant that we never see when we look at it in the garden or in a greenhouse, but rather things that are going on internally that might affect the qualities of the plant, but nevertheless are not those what scientists would call phenotypic aspects of the plant.
And so can you give me a timeline in a way from ordinary manipulation of the natural world that maybe we would have seen really since farming began, taking one species, taking an individual plant with specific traits and privileging those traits and breeding through those traits, through to more industrial processes, and now with genetically modified organisms and onwards? Would you see genomics, this idea of gene editing and CRISPR, as a new thing beyond GMOs? So can you just explain to me what the distinctions are between all of these things? Partly I'm asking because maybe one argument is that really new technologies are not that different to what people have been doing all along.
It's a good question. So I'd hesitate to call it a timeline simply because, of course, traditional breeding methods are still very important today. So it's not that these things are only in the past. But if we're thinking about the traditional breeding, it sounds like what you were describing there is your basic crossing of different varieties together to try and produce variation. So if you see one rose that maybe you think is very beautiful, but it has terrible disease resistance, you might cross it with another rose that has good disease resistance, hoping that the progeny will be much better on both counts. So that's your classical breeding that people would know of and think of. But classical breeding can also involve other techniques. So I kept alluding earlier to the fact that plants will themselves randomly mutate from time to time, just because they're out in the sun or they've been experiencing a new environment or seemingly just because they feel like it. And so you might find that if you're growing a tree, like an apple tree, that all of a sudden a branch might just have a mutation and start producing very different types of apples from the rest of the tree. And you can take that, graft it onto something else, and begin growing it more. So those are the kinds of traditional techniques that were used, let's say, back in the 1920s. Around that time, we also start to see different techniques. So people realized that these mutations were occurring, and they began to figure out that it was because of things like radiation from the sun or from exposure to chemicals. And so they started using those techniques to try and trigger more of those mutations and see what sprung up from it. And so different chemicals, different forms of radiation as we discovered them became available, and people were very keen to start using them throughout the mid-20th century. Those things, again, are still used today. But then in the 1980s, with the advent of biotechnology, what we're talking about there, when you mention genetically modified organisms, is this technology that became available to start taking genes from perhaps a different species entirely, or just from a different plant of the same species, and inserting it directly into another plant. The reason why this was so exciting is that with crossing of plants, it's very random. Anyone who's had children knows how random it is when they come out, how much they're like either parent. Same thing with plants. And so to try and reduce that randomization, what people got excited by was the idea of being very specific about which gene it was that you wanted to insert and doing that. Now, it got very controversial, as you say, with genetically modified organisms because, on the one hand, people were a little bit uncomfortable with the idea of being told that we've got this great cotton that you can use now. It's got a random gene in there from some bacteria, but don't worry about it. It's completely fine. Very easy to market that as something that could be quite dangerous. So that was where some of that controversy came from, but also the fact that with that genetic modification came patents. People started to use patent law as a way to control the circulation of plants that contained those genes. There was some very high-profile litigation against farmers that came out of that. And so in the public consciousness, genetically modified organisms became associated with all these negative ideas about unnatural crossings, about patent law and monopolization of food and other important plants. More recently, having learned some lessons from that, we've seen CRISPR come on the stage. And so this is the technology that many scientists, when they're trying to explain it, they call it the genetic scissors. The idea that you can come in and just make very small snips on the genome of the plant, just trigger these tiny changes that are almost like a mutation. So you're not inserting a whole gene from a different species, but rather just making those tiny edits in order to modify the expression of those genes in the plant. So it's seen as being less dramatic, and therefore there's a lot of discussion going on at the moment about whether we should really treat that technology as the same thing as genetically modified organisms in the sense that we talked about them in the 80s and 90s. And this has been a huge point of debate at the moment in the EU.
So if I want to identify a plant variety that's been created in this way, I'm really going to have to look at the molecular level, aren't I?
You would, although with something like the CRISPR editing, it's often not even possible, even if you do the genetic sequencing, to tell whether or not that's a plant that was produced by CRISPR or whether it was just something that arose randomly in the plant through these older forms of changes through mutations.
But that makes things very difficult for an intellectual property lawyer, because unlike a book or unlike a brand name in the supermarket, we actually can't tell which is the property that we claim ownership over.
Exactly. This can make it very tricky. It means that for even other breeders who might be acting completely honestly, they might, through other processes, come up with exactly the same genetic sequence in their plant. They're not directly infringing in the sense that they've taken and physically, appropriated what the other person has developed, but at the same time ended up with the same result that would be infringing that patent. And so this is where things have gotten very controversial now in the EU, because on the one hand, Europeans, and indeed in the UK as well, there have been efforts to deregulate and say, well, CRISPR, it doesn't cause some of the same concerns as genetic modification did. We shouldn't be imposing the same strict regulatory requirements to prove safety and efficacy and so on that we have for GMOs. Make it easier for these plants to be introduced to the market and deregulate them that way. That has then triggered this conversation, particularly when things went to the EU Parliament, of saying, well, hang on a minute. If we're going to encourage this technology to be used in Europe, what about the patents? What is this going to mean? Is it going to increase the use of patents in this area and make it harder for European breeders to access those genetic sequences or those technologies? And if so, what are we going to do about it? And so where the EU Parliament stepped in was to say, well, we've got a very simple solution. We just ban patents entirely for anything to do with gene editing. Now, on paper, that looked very simple, but as you can imagine, once you start to ask the question, does this patent have to do with gene editing or is it to do with some other genetic technology? Drawing those distinctions can be extremely difficult, even if you're a scientist or a patent lawyer. And so that causes massive problems of ambiguity. But then the second order problem is that when people heard this news, patent lawyers, economists, and governments got quite concerned because coming back to that narrative that intellectual property is meant to be this kind of incentive, if you take away that incentive, the concern would be that Europe is no longer an attractive place to be doing breeding and using these technologies, and that maybe all of the industry and all of the research moves to places where it's allowed, like America or China.
Do you think, putting aside the rights and wrongs of it, that part of the European concern is almost around the idea that this kind of innovation in biology risks being an enclosure of certain kinds of agricultural activity or of the natural world itself? Again, using the natural world as being something that we can essentialize incorrectly.
I think that is one of the big concerns here. There are massive concerns about the control of the agricultural system. And one of the things that has been going on since this debate started in the EU are a lot of studies trying to ask this question, well, if we've had patents for so long on plant-related traits and so on, what is this picture looking like now? We've had this for decades. By now, we should be able to get some kind of measure of whether or not that concern about monopolization of agriculture is actually coming through. What we're starting to see from the preliminary studies, though, is that the picture is quite complicated. Maybe for some species that is true. If we look at America, for example, it is certainly true that for things like soybean and cotton and wheat, there is a lot of monopolization that happens, and particularly through the patent system. But when you look at the rest of the food system, the picture is way more complex. You have a lot more small breeders involved, even individual breeders still contributing and getting IP rights. And so the question starts to be, do we even differentiate on the basis of which crop we're talking about? Now, the Europeans are still trying to find a way to square that circle and address these concerns without being as radical as the EU Parliament was. And so this year, what we're starting to see is a move towards transparency, to say that if we're concerned about people having all these patents and that becoming an inhibitor for sharing of these technologies, maybe if we force them to disclose what patents they have and try and introduce mechanisms to encourage them to license that more freely, that might be the way to solve the problem. That's what got put forward. The negotiations failed earlier this year, and they're going to try again in the next few months, I believe. But people are still concerned that even transparency measures really don't solve the problem. And so where we're at the moment is this tricky situation where everyone to some degree recognises the issue here around this ownership and control, while at the same time having massive disagreements about what it is that would even solve the problem. Because, coming back to the whole point of my research, we still don't really have a clear picture about what the effect of plant IP really is. We don't have definitive empirical data that tells us one way or the other whether or not these are detrimental to food security or detrimental to biodiversity. And so having that longitudinal picture, looking over decades or even the last century to say what has been that impact of these rights, is going to be absolutely crucial for us to even start to address these policy concerns about whether or not we need to ban patents, whether or not transparency and licensing could solve those problems, or whether something else is required.
Thanks very much, Jocelyn. That really is a great segue to talk about the fellowship itself, that century of propertising plants. What were the gaps in the research that you're really trying to address there? And when you're working on a longitudinal study of this kind, what's the method in a way? How are you going to approach the study?
Well, it's a very ambitious project because what I'm trying to do, as you mentioned, is to try and get a century of data collated to be able to answer this question. Fundamentally, what I'm trying to do is picking up on a study that I alluded to earlier about vegetables in the United States. So there was a study done by Susanna Chapman and Paul Heald on the US looking at how varietal diversity had changed over time, responding to these many publications over the years that had said things like we've lost 94% of all varietal diversity in the 20th century. Catastrophic numbers that were being quoted. While at the same time, we're seeing all these narratives I mentioned earlier about economists being very excited by IP, but then when they started looking for empirical evidence that IP is supporting varietal innovation, coming up with very more complex answers than they perhaps thought they might. And so Heald and Chapman did this study where they realized that those who were making these claims about this catastrophic loss of diversity, what they had actually been doing in the past was saying, let's go back to the seed catalogues that farmers were getting back in the 1910s, count how many varieties are on there, look at how many of those varieties are still available on the market, and compare that with what is in seed banks at the moment. Now, you don't have to be much of a scientist to realize that what is being compared there are two different things. They were comparing variety catalogues with species that are kept in seed banks around the world. Think of your Svalbard seed bank that's up in the Arctic. Very different things that you're counting, a variety versus a species. So if you're comparing apples and oranges, that's not going to give you reliable data. And so what Heald and Chapman started to do was develop this methodology where we say, let's look at those seed catalogues and compare them to what is currently in seed catalogues at the moment. Now, they look very different these days. These days in Europe, they look like things like our national list or the EU Common Catalogue of varieties that are on the market, but can also be contained in things like the Royal Horticultural Society's databases of varieties that are currently on the market, as well as records that are being kept by different organisations. There's many community groups out there, from community gardens to orchards that are deliberately trying to maintain heirloom varieties and keep them available. All of these different networks of information that we can pull together to try and get an accurate picture of how many varieties are currently available. So we'll be asking that question of how many of the old varieties are still available today, but then taking into account that new innovation that has happened since then to ask how many new varieties have been brought onto the market.
What do you think, if you're hypothesizing, you'll find? Do you think that you're going to find a complicated enough picture there of some expansion and some contraction? Do you think that's kind of species-based, or do you think it's to do with marketization of some species? So, for instance, soybeans that you're saying, where there are, they become a kind of a staple crop in a way for, in the United States and Europe. What's going to be the driver of that expansion and contraction, assuming that that's what you find?
I think that's right. I am assuming that it will be a complicated picture. The question is complicated in what ways? One of the expectations that I have, as you mentioned, is that we're going to find a different picture depending on which plant we're talking about. So what I've decided to focus on initially is a different spread of species from what Heald and Chapman did. So I'll be looking at apples like they did, but I'm also very interested in potatoes, very interested in barley and oats, and also interested in roses. Now, that might seem a bit surprising given that a lot of the focus of the project is on food security, but there's a few important things to remember. One is that, of course, roses can technically be edible, although they're not really a staple part of anybody's diet. But roses are also very commercially important. We see them all the time in gardens. They sell quite well. And when we look at the data of filings for plant variety rights, roses dominate. I think the last estimates I saw were that half the plant patents that are granted in the US are for roses. Just roses, that's it. Then we take into account the symbolic importance of them. Culturally, of course, giving roses to someone carries a lot of connotations. They're national flowers of the US and of England. And so thinking about these important plants and how we're conserving them, what does plant IP do to the diversity of varieties that we have available to us? These are things that I'm very interested in pursuing. The other reason why I'm looking at different types of plants is because plants are bred differently because each plant is unique. Some of them you can breed by crossing them. Some of them rely more these days on genetic modification, and others might rely on mutations and other forms of breeding.
And you mentioned community groups. Are you going to go and talk to community groups and try and extract the data that they hold?
Well, I don't like the word extract, but that's a very...
I was going to correct myself.
Well, don't correct yourself, because it's actually a good prompt to kind of talk about what I'm trying to do. So I certainly am not trying to extract data from anyone in an exploitative sense, because what I'm really trying to do here is to ameliorate what we've got already, which is that we have disparate groups who are sometimes working in their own ways on conserving these resources. We're talking about everyone from university groups of researchers who perhaps have their own gene banks to these community groups who are interested in a particular species and mainly in heirloom varieties. And what I'm trying to do here is, of course, to see what data they have that could be fed into the study, but the study should also be feeding back to them. It's going to be bringing in data from other jurisdictions, from over time periods where maybe they didn't have access to those materials. And so through my work in the archives, bringing that data to them and then sharing across those different groups, what I'm really hoping to do here is start a very important conversation about good methodology for measuring diversity in the varietal innovation context, and allowing us to then scale that up to other species, other countries, and start to ask really important questions about what it is that plant IP is doing. Because for decades now, we've had the same narratives being repeated. On the one hand, governments being very positive and going around and telling other jurisdictions that, yes, Nigeria, you must sign this free trade agreement. And by the way, please make sure that you have plant variety rights. Or going to South America and telling them that, don't worry, this will be great for all your indigenous communities. They will love this and will still be able to have all of their culturally important varieties. Certain narratives have come up in that context, but then I still want to turn the attention back to Europe and ask, what about here? What about the culturally important varieties that we have in this country?
So if you went to an artisanal apple breeder in Armagh, for instance, where, there's a lot of apple breeding going on, what are you offering them in a way? It's really interesting, I imagine, to think that as a lawyer and as a student of law and property, you can engage with people who are doing something different maybe in their view, which is simply growing species out of love for the species.
It's a good question. So certainly I'm thinking about this from the historical point of view, that people may be interested to understand where these laws have come from and the impact that it is having. And certainly I think that the data that I'll be collecting will be interesting. But it's also important to remember, coming back to the point I was making about plant IP being a bit unloved as an area of law, is that misunderstanding allows for misconceptions to permeate. And it also allows people who perhaps have different agendas to push a particular narrative about what plant IP is and what plant IP does, that people may take as given. And some of those narratives, frankly, need to be challenged. And so what I hope to do as well is, from the doctrinal side even, to start to shed a bit more light on what these criteria for protection are actually doing. How does plant IP interact with other regulations, like those seed marketing regulations that I mentioned, to think about that complex web that many of these growers would be very aware of, but perhaps some of the legal complexities have been misrepresented over time or misunderstood, and clarifying exactly where the issues are, that if they are facing problems with conserving the diversity of varieties, what is actually causing that? And once we can accurately identify that, figure out what we can do to change it. Because maybe as part of these conversations about gene editing and the way that's triggered important reflection on the role of the IP system, maybe there's more questions that we need to be asking. I mean, I think it's quite telling, actually, that the EU Parliament is so focused on patents, but has given absolutely no attention to plant variety rights and whether any changes are needed there. Now, I love plant variety rights, but I don't think the system is perfect. And so I think it perhaps betrays a lot more ignorance than interest to be just focusing on patents as the source of the problem.
Do you think that for an artisanal plant breeder, they need to be protected from plant variety law, or do you think they can be protected by it?
Well, I certainly don't think they need to be protected by it per se. So I'm not going around to any of these groups and telling them that they all need to be filing for plant variety rights. But at the same time, I do think it is important to understand what exceptions and freedoms are built into this system. As I mentioned, this is a system that was designed with breeders in mind. And so through it, there are things like the breeder's exemption that specifically say that if you're using a variety that is currently protected and it's within that duration of protection, you can freely breed with it all you want and there is no infringement there. Now, if you commercialize that variety, that might be a different question, but you can experiment all you want with different crossings and working with it. That is something that is already in the system and something that I think needs to be quite vigorously protected and perhaps expanded. That maybe, this is a question that I'm exploring at the moment, when the EU Parliament says they're worried about patents having creating too much of a monopoly, well, maybe the answer is that we need to do what they did in the Netherlands and a few other countries in Europe, which is to say, that's fine, but we're introducing a breeder's exemption into patent law as well then. We're going to make sure that this system that was designed to have monopolies starts to bring in these other exceptions to recognise that breeding is a different science from perhaps the pharmaceutical industry and needs to have some bespoke elements in there.
Very interesting, isn't it? Because we're trying to draw boundaries where really there are no absolute boundaries and there can't be boundaries. So law will step in to manufacture a boundary between something we might call breeding and a more industrial or chemical process, as imagined. Would that be right? Tell me a little bit about food security and the interaction between plant IP and food security.
This is another complex aspect of it. So the narratives around food security are, on the one hand, that if we're constantly encouraging people to breed better varieties, that promotes food security by making sure that we have new varieties coming on the market that can respond to the new diseases or heightened diseases that are coming into play, as well as having things like better yield and more efficiency, particularly in the face of things like climate change, making sure that we have resilient crops that are available. So that's the hope of what plant variety rights would achieve. But then when you start to analyse it, and this is where the doctrinal aspect can be so important, actually things like yield aren't recognised in the plant variety rights system as something that can distinguish a plant necessarily. What they're more focused on that we mentioned earlier are those phenotypic characteristics. What's the shape of the leaf? How tall does it grow? What's its habit when it's growing? Is it shrubby or is it more tall? If you're focusing on those aspects, it really doesn't address the concerns that we have often around food security. Now, this is where, of course, the seed marketing regulations do have quite a role to play. They do ask questions about what is the yield of your plant? How disease resistant is it? So in that space, we have other regulations that are separate from, but parallel to the IP system that are trying to make up some of that work. But then we need to start asking important questions about the interactions between those two areas of law. Are they working in harmony? Are there ways that we can better address the climate crisis through those laws? Is it better to incorporate that into the IP system, or should we just focus on the marketing, even of varieties that aren't protected by IP?
Really interesting, and interesting to think about how different areas of law, as we'd understand them as scholars, interact and intersect with each other when we come to enormous policy challenges like climate change.
Exactly, and I think it's quite telling that patents so quickly entered the picture when the NGT regulation debate started happening and when we started talking about CRISPR. But then the current ongoing efforts in the EU to try and overhaul the seed marketing regulations, IP has not so much come into the picture there. And so I think it's interesting that patents are seen as important in one context, but plant variety rights and seed marketing, that dynamic is not getting so much attention when I really think it does need more.
So tell me, what are the main instruments in Europe and the UK around plant variety rights?
So obviously the picture has changed since Brexit, but before Brexit what we had was an EU-wide regulation that allowed people to get plant variety rights that would cover the whole of the EU. These days, of course, we still have our separate legislation in the UK, so you can get UK level plant variety rights under our Plant Variety Rights Act. It's a very nicely named legislation. Or you can file under the EU Plant Variety Rights regulation and get that right. So the two can work in parallel and get you your full coverage.
So Brexit's an issue here because I presume would I have to apply twice to an EU body and to a UK body for plant variety rights?
Exactly. And so now you're paying two application fees where previously you would have paid one. And importantly, with plant variety rights, I mentioned earlier about the criteria that in order to show that, you have to test the variety. And so you need to grow it out over various cycles to have someone look at it over months and say, is it actually distinct? Have we got that nice uniformity? That's something that requires a lot of money to be able to get it in the field and have someone do that examination.
Interesting. Okay, right. A last question. Do you want to sum up, in a way, you've got a long time for this fellowship. What do you think at the end point you would like to see in terms of the scholarly contribution the fellowship will have made and you'll have made as a scholar building this area of law?
You are right that it is a long time, although it feels terrifyingly short the more time I spend trying to collect the data. It's a very ambitious project. The amount of data that I want to bring together, the different groups that I'm trying to bring into this research and make sure that they have a voice in how the research is designed and the outputs from it. It's a lot. And so I'm really looking forward to it. And in particular, given what a behemoth it feels like at the moment, I'm very excited to be recruiting a team. So I'll be having a postdoc and hopefully a PhD student joining me on the project. And so that part I'm very much looking forward to, seeing them come to grips with this topic and engage with it and contribute to that data collection and the outputs from the project. Now, we mentioned at the beginning that I've entitled this project A Century of Propertizing Plants. And I also mentioned about the Plant Patent Act of 1930 in the US. This is very much the hook for this project, that within the 7-year life of this project, we're going to hit 2030, which is going to be the centenary of that legislation, the first legislation to provide any kind of plant IP rights. And really what I'm trying to do here is to take that moment, not so much because I think the Plant Patent Act is worthy of celebration, but rather as a nice opportunity to look back and have a neat number of years to think about the impact of what this kind of legislation has done and ask the question whether we want to take these kinds of rights into the next century, and if so, in what form.
It's so fascinating. I'm really looking forward to seeing it come to fruition and to hearing from you, and I hope, about the project as it grows and develops. Thank you very much, Jocelyn.
Thank you for having me.